Welcome, I'm David Ricks. I'm a personal injury trial lawyer in Rancho Cucamonga and the principal of the Inland Empire Law Group. Every business owner has a responsibility to maintain their property in a safe manner so that the patrons and those who come on the property can do so safely. This is called a duty to inspect. In other words, the property owner has a responsibility to routinely inspect the property and make sure the conditions are appropriate to minimize the possibility of their patrons falling and injuring themselves. I'm going to give you an example of a case I handled a number of years ago. A lady was leaving a store and walking out to the parking lot. As she walked out the parking lot, she stepped off the curb, and as she stepped down, she stepped into a depression in the asphalt. And because she didn't realize that it was a little bit further down than the rest of the asphalt, she lost her balance, fell on her ankles, and broke both her ankles in the fall. So we brought a claim against that property owner for its failure to inspect the property. Well, what we learned is that allegedly inspections took place quite routinely, but supposedly they never saw this depression in the asphalt. Well, this would be negligence on their part to inspect the property but not see something that was fairly evident to any proper inspection that may have taken place. They tried to allege that my client should have seen an open and obvious condition. The question was that over the span of many months, why didn't the employer or why didn't the property owner see that depression if it was so open and obvious? So there is a duty to inspect, and that's one of those things that we look for when we're pursuing a claim of a trip and fall, slip and fall, or some other injury on a business property, is whether or not the business property owner and its employees did proper inspections to eliminate or reduce the risk to their patrons.